Hello and welcome to The Explainer. Today we are diving into a subject that might sound a little dense, but trust me, it's absolutely vital to how our government works. It's called administrative law. You can think of it as the legal operating system running in the background, making sure that government power has limits and that public bodies are, playing by the rules. So let's get into it.
Here's how we're going to break it all down. First, we'll look at the fundamental rules for controlling government power. Then, we'll talk about judicial review, which is kind of like calling in a referee. After that, we'll explore the big debate about where judges even get this power. Then, we'll see what fairness actually looks like in the real world. And finally, we'll cover what you can do about it, your rights, and the available remedies.
So let's start with a question I'm sure we've all considered at some point. What happens when a government agency or your local council makes a decision that affects you and it just feels wrong? Maybe it seems completely random, or maybe they didn't even bother to hear your side of things. Well, this is exactly where administrative law steps in. It's the system that gives you, the citizen, a way to challenge that power.
Okay, on to our first section. The big idea here is that government isn't some kind of free-for-all. There's a whole legal framework in place, the rules of the game, if you will, designed specifically to put guardrails on what public authorities can and can't do. So, at its very heart, administrative law is about one thing: controlling government power. Every single public authority, from a top government minister right down to a small local committee, has to follow these rules. And if you take away only one thing, let it be this core principle: there is no such thing as absolute or unfettered power. That one idea is the bedrock of this entire legal world. I love this analogy. Think of government power as a huge flowing river. It's strong, it moves, it makes things happen. But the legislation, the laws passed by Parliament, are like the banks of that river. They're there to channel all that power, keep it within its limits, and stop it from overflowing and, causing a ton of damage. Now, it's important to know that not all government power is created equal. On one side, you have what's called a ministerial duty. This is pretty mechanical. If you check all the boxes, the official has to do the thing. There's no choice involved. But then you have the other kind, discretionary power. This is where an official has to use their own judgment and wisdom to make a call. And it's almost always the use or misuse of this discretionary power that ends up in court.
And that idea of challenging discretionary power leads us straight into our second section, which is really the main event of administrative law: judicial review. This is when the legal system calls in a referee to check the play.
So what is judicial review? Well, it's basically the process where you ask a court to be that referee. Now, the judge doesn't get to sub in and play the game themselves. Instead, their job is to check if the original decision-maker played by the rules. The key question isn't, was this the right call? It's, was this call made lawfully?
And this is a super important point to get your head around. A review is not an appeal. An appeal is all about the merits. It asks the court, was this decision right, and invites the court to make its own decision. A judicial review is completely different. It's only concerned with the process. It asks, was this decision made lawfully? The court isn't there to second-guess the official's judgment, just to make sure they stayed within their legal boundaries.
So, what kind of rule-breaking are we talking about? Well, challenges usually fall into one of three big categories. The first is illegality. Did the decision-maker go beyond the powers they were actually given by law? The second is irrationality. Was the decision so off the wall that no reasonable authority would have ever made it? And the third is procedural impropriety. Was the process itself unfair? Did they not follow the proper steps or just fail to act fairly?
All right, now we're getting to the really fascinating, kind of philosophical part of all this. It's one thing to say that courts can oversee the government, but where do they get that power? Who gave them that authority? It's a massive constitutional puzzle. There's this huge debate that really boils down to two competing ideas. On one hand, you have the traditional ultra-vires theory. It says judges are just enforcing what Parliament wanted all along. They're making sure officials stay within the lines drawn by the law. But then there's the more modern common law theory, which argues that judges are actually applying fundamental principles of justice, principles that they themselves have developed over centuries to uphold the rule of law.
This quote really nails the traditional view. The argument is essentially that the court's power is only legitimate because it comes from Parliament, which is elected by the people. The court is just acting as an enforcer for Parliament's rules. It's very neat
tidy, and constitutionally proper way of looking at it.
But here's the fiery counterargument. This view says that pretending Parliament intended all these detailed fairness rules is just a fig leaf, a convenient story. The reality, it argues, is that judges created these principles, and so judges should stop hiding and just admit it, and be willing to defend those principles of justice on their own merit. It's a much bolder claim. Okay, enough of the high-level theory. Let's pull this back down to earth. When we say judges are upholding fairness and legality, what does that actually mean for you and me? What does it look like in practice?
Well, it comes down to these core building blocks, which lawyers often call natural justice. Things like the right to a fair hearing, to have your side of the story actually heard. The rule against bias is a huge one. You can't be a judge in your own case, right? And increasingly, there's a duty for public bodies to actually give you reasons for their decisions. And finally, the law can protect your legitimate expectations. If an authority makes a clear promise about how they'll act, they should probably stick to it.
Now, remember that irrationality ground for review? Here's the classic test for it. And just listen to how high the bar is set. A decision has to be so unreasonable that no reasonable authority could ever have come to it. It's not enough for a judge to just disagree with it. It has to be completely beyond the pale. And that super high bar is there for a reason. It stops the courts from interfering in policy choices that are properly for the government to make.
All right, so let's imagine you've gone through the whole process. You went to court, you made your case, and you won. The judge agrees the decision was made unlawfully. What happens next? This final section is all about the payoff, the remedies. What can the court actually do to make it right? The courts have a really powerful set of tools here. The big one is a quashing order, which basically hits the delete button on the unlawful decision. It's as if it never happened. A prohibiting order can stop a public body from doing something unlawful before they even start, and a mandatory order can force them to do their job, like issue a permit they've been wrongly holding back. The point is, these aren't just symbolic wins. They have real power to fix the problem.
And let's end with a huge question for our times. More and more, government functions, everything from waste collection to running prisons, are being contracted out to private companies. So the massive challenge for the future is this. How do we make sure that these vital principles of fairness, justice, and accountability, the very soul of administrative law, actually follow the power when it moves into private hands? That's a puzzle that will define the next chapter of this story. Thanks for joining me on The Explainer.